Hello, everyone. We're going to begin in just a minute while we let people enter the room and get their sound set up, because it looks like people are still connecting to sound. Okay, let's begin. Welcome, everyone. Thank you for joining us for this Title IX community conversation. About a year ago, we were convening in anticipation of these new regulations, and in the meantime, an awful lot has changed in our world. My name is Glenna Chang. I'm the Associate Vice President for Student Life, and I'm very grateful to have been asked to facilitate this important conversation. I have a lot to cover in this intro, so please forgive me for reading some of it so I don't forget anything. Before we begin, I need to take a moment to acknowledge where we are in the country today. Violence and oppression based on race and violence and oppression based on gender are linked, but they have not always been allied. I want to recognize that gender equity is the subject of today's forum, but there is no equity of any kind so long as there is violence and oppression of any kind. Our work ahead is to remember that gender equity efforts must be advanced with an anti-racist approach, an anti-oppression approach, and an anti-trauma approach. I'm afraid that's not exactly the nature of the laws that we've been asked to implement, but that will be the reason why we come back to our values again and again in this process. Yes, we can follow the letter of the law, but we can do so much more than that as a UW community. Our purpose today is to understand how the new federal rules are likely to impact UW and how UW is planning to come into compliance and how you can provide input to that. I want to acknowledge the impact on our community, the current state of the world, and that this topic can be upsetting. We are all a little bit raw right now. A few housekeeping items. Your video is turned off and you are all muted. All exchanges can be directed to me directly via Zoom chat. If you're having technical difficulties, chat that to me as well, and we'll see if we can get you some support. This session is being recorded, and we expect that it will be posted on the Title IX website within a few days. So if you're unable to stay in this meeting, you can always view the recording later. For our session today, our Title IX coordinator and Deputy Title IX coordinator will present information, and then I will pose questions to them and other panelists that you've all sent to me via the Zoom chat feature. As stated in the meeting registration, we may not be able to get to all of the questions, but email Title IX, that's Title IX, at uw.edu with any questions that do not get answered. So at this time, I'd like to introduce our speakers. Valerie Richardson, UW's Title IX coordinator. Mags Alex, UW's Title IX deputy coordinator. Ian Messerly, UW's manager of University Complaint Investigation and Resolution Office and Title IX Investigation Office, which are the units that investigate sexual misconduct against students and employees. Valerie, would you like to kick us off?
Great. Thank you so much, Glenna, for that welcome and those words to get us started. And thank you so much for everybody who is attending today and for the folks who helped pull this together so quickly. Given the limited time that we have today, I'm just going to jump right into our content. First, let me just reiterate that Title IX is the federal gender equity law. The majority of policies, practices, and services to date related to Title IX are a result of guidance that was issued by the Obama administration in 2011 and 2014. That guidance was rescinded by the Trump administration in 2017 and replaced by very minimal interim guidance, which was then followed by a notice of proposed rulemaking issued in November of 2018. Proposed rulemaking is phase one of making formal regulatory changes that go beyond guidance and instead have the force of law. In January 2019, the University of Washington submitted a detailed 20-page comment as part of the notice and comment period. You can find our comment, or many comments, in the Title IX news blog on the front page of the Title IX website. After we submitted that, we waited and waited, and on May 6th, just a few weeks ago, the Department of Education posted the 2,000 plus page final rule during a pandemic, which required implementation by August 14th. This gives schools just less than about 100 days to come into compliance. It was clear after our initial scanning of the lengthy rules that most of the concerns we had identified in the proposed rules remain in place, and in addition, new requirements were included. 2,000 pages is a lot of content for anyone to digest and to problem solve, and we're immersed in that process right now. We'll share our thinking with you today and also ask for your patience as we may find ourselves needing to adjust or react as the Department of Education offers additional clarification and we complete more in-depth analysis. For today, we'll focus on key issues and may not get to everything you want to discuss. Please send your questions, like Glenna said, during this community conversation to her directly via the Zoom chat feature. And remember, you can always email Title IX, TITLEIX@uw.edu with questions after the conversation as well. Before we start talking about the new federal rules, I want to talk a bit about our commitments as a university in the gender equity space. I want to underscore that the University of Washington is committed to providing respectful learning and working environments. We're committed to preventing and responding to discrimination, harassment, and violence, regardless of where it occurs. And we're committed to showing leadership in achieving gender equity. With all of those commitments in mind, we also are committed to starting with compliance as the floor, the foundation from which we can build from and around as we proceed. I will pause there and reiterate that these rules are slated to become federal law on August 14th, and UW must and will comply. As you're likely aware, these new rules from the US Department of Education are controversial. Many of us who work in this realm of gender equity, civil rights investigations, and prevention of sexual violence and harassment have concerns with the final rules. We don't believe that they will result in more equity or due process. We already have those elements fully enmeshed in our UW systems. We don't believe that in every case they reflect many of the best evidence-based practices that we have worked to incorporate into our own UW policies and protocols. And finally, these new rules are resource intensive, and we believe university funds could be better utilized for the benefit of our students and the broader UW community. We are not alone in our concerns. Over 120,000 comments were submitted to the federal government during the notice and comment period, and one analysis indicates that over 90% of those comments were in opposition to most or many elements in the proposed rules. Now, all of that said, I want to reassure everyone listening today that despite our respectful disagreement with the Secretary of Education's new federal rules, those rules will not prevent us from continuing our work to both address and prevent sexual harassment, sexual violence, and other forms of sexual misconduct. Specifically, UW is committed and will remain committed to addressing all forms of sexual misconduct and offering and prioritizing support measures and options to survivors. We will continue to provide due process and support resources to respondents. We will continue to prioritize equity and fairness, and we will proceed with developing our prevention and awareness initiatives. Now, before I turn it over to Mags to walk through some key elements of the new rules, I just want to offer a few general observations. First, these new federal rules apply to everyone. The new rules apply to both employees and students. An employee who is alleged to have engaged in conduct that falls within the newly defined federal definitions and jurisdiction will receive the same level of due process as a student. And similarly, an employee who files a complaint and requests an investigation will have the same process rights as a student complainant. The definition of sexual harassment has been narrowed, and Mags will explain that in a little bit more detail in a moment. And when conduct meets their narrow definitions and jurisdictional rules, the regulations are very detailed and prescriptive in how a school must investigate and conduct hearings. Because of this narrow definition and jurisdiction, and because UW is interested in maintaining its commitment to preventing and responding to a broader range of conduct, we will be assessing complaints to determine if they must be adjudicated via the new federal rules or if they will be adjudicated via current UW processes. In short, we will have a two-track system, and every allegation will need to be assessed up front to determine which track it will follow. Now, just a word about enforcement. These rules are enforced by the United States Department of Education. If a school does not comply, does not abide by the regulations, the school could lose their federal funding. Students who receive federal financial aid and researchers working on federally funded grants are among those who have an interest in the University of Washington complying with these rules. Further, unlike prior guidance, these rules will have the force of law. Lastly, litigation is expected, and some suits have already been filed. It's possible that these rules could be enjoined and their implementation postponed or otherwise impacted, or there may be no delay or change. And with that in mind, we have to be ready to implement by August 14th. Now I'll turn it over to Mags to give an overview of what the new rules will require. And remember, as questions occur to you, please type them into the chat feature to Glenna so that we can respond. Thank you.
Thank you, Valerie, and thank you everyone for attending and for your interest in this topic. First, I'm going to discuss the conduct to which the federal regulations pertain. Many types of conduct can be considered sexual harassment, and there's already a high bar for what constitutes sexual harassment under law. The federal regulations set that bar even higher by narrowing even further the definition of sexual harassment. The regulations require that a school respond to the following types of conduct: sexual harassment that is quid pro quo or something for something. Think of this as either getting a specific grade or promotion or avoiding a consequence like being fired as being dependent upon whether someone complies with requests for sexual favors. The regulation specified that quid pro quo harassment only applies where both the complainant and respondent are employees, or where the complainant is a student and the respondent is an employee. The regulations prohibit unwelcome conduct on the basis of sex that is so severe, pervasive, and objectively offensive that it denies a person equal access to their education or workplace within an academic environment. This is similar to the hostile environment sexual harassment that the University of Washington currently prohibits. The difference, however, is that UW currently prohibits unwelcome sexual contact that is sufficiently severe or persistent or pervasive such that it creates what is referred to as a hostile environment. The university's current definition aligns with other federal and state laws. The difference of the conjunction and instead of or further narrows what conduct is prohibited pursuant to this federal regulations. The university's current definitions of sexual assault, dating violence, and domestic violence are broader than those to which the regulations cite in the Clery Act and the Violence Against Women Act. The university's definition of stalking is the same as what was prohibited under the federal regulations. Fortunately, the regulations do not prevent schools from responding to and investigating a broader range of conduct than that which the University of Washington currently does and will continue to do so. So moving on to the next slide. Now that we know what conduct is prohibited, what the regulations actually require, do the regulations actually require the university to do? It depends on what we learn, how we learn it, and what the person who experienced harm or wants the university to do in response. When we receive a report, which basically means when someone discloses that they experienced sexual harassment or were harmed, we must offer supportive measures and ensure a complainant knows how to make a formal complaint if that is what they wish to do. Advocates will remain a key partner. Advocates already inform complainants of supportive measures, and I'll cover what those are in a bit. Advocates are also the best source of information for a complainant who is in the process of deciding whether or not to make a complaint. Conversations with advocates are confidential, which allows complainants to explore their options and ask questions before making a decision about whether they want the university to conduct an investigation. Under the new regulations, complainants will continue to be informed of how to make a formal complaint, as well as how to request an investigation under University of Washington policies. In some cases, a complainant might want to request an investigation that involves behavior prohibited under both the federal regulations and under University of Washington policies. Complainants will also retain the choice not to request any investigation or file any formal complaint. The regulations allow the Title IX coordinator to request an investigation, even if a complainant does not want one. This is also currently true, and the university has never yet overridden a complainant's choice. The regulations require that the university offer supportive measures to respondents as well, and we currently engage in this practice. A respondent resource works with student respondents to implement supportive measures at this time. A formal complaint must be made by someone who's participating in or attempting to participate in one of the university's programs or activities. The Title IX coordinator can also make a formal complaint. This will limit who's able to make a complaint under the federal regulations as compared to what is happening now. However, the University of Washington's current processes will still be available and allow anyone who currently could make a complaint to be able to do so in the future. Formal complaints filed in accord with the new regulations will be assessed to determine whether the alleged conduct fits within the narrower definition of sexual harassment and whether the alleged conduct occurred in a location to which the federal regulations apply. In some cases, specifically where the conduct alleged either is not prohibited by the federal regulations or did not occur in a specific location, the regulations require that the formal complaint be dismissed. If and when a dismissal of a formal complaint occurs for the purpose of the federal regulations, investigators will consider whether the allegations could be investigated based on existing university policies. If so, investigators will provide that option to complainants, and an investigation may be opened pursuant to the University of Washington's policies and procedures. Again, as I'm talking, please remember to type any questions that you have for us in the chat feature, direct those to Glenna, and then we'll respond later in our presentation. So moving on to employee responsibilities. As I discussed how the university is required to respond under the new regulations, under the last slide, I mentioned that that is in part dependent upon how we learn of information. The regulations change the requirements about employee responsibilities. Previously, federal Title IX guidance imagined that when certain employees, referred to as responsible employees, learned that someone might have experienced sexual harassment, those employees needed to take action to ensure that the school would respond to the disclosure. The new regulations changed this framework and eliminated the concept of the responsible employee. Instead, the new regulations narrowed the requirement so that a university is only required to respond when the Title IX coordinator or a smaller group of employees with the ability to institute corrective measures learn of a report. And remember, report effectively means disclosure related to sexual harassment. Thus, unless the smaller group of employees, all of whom will be notified that they're deemed individuals with the authority to institute corrective measures once the university determines who those folks are, once that group of people learns about sexual harassment, the federal rules do not obligate the university to respond otherwise. Though the regulations narrow when a school has to respond, the regulations explicitly allow schools to establish other expectations for their employees. The University of Washington will maintain its expectation that employees follow the Title IX Safe Campus Protocol. So what this means is that when employees learn that someone may have experienced sexual harassment or other types of sexual violence, they should call Safe Campus. Safe Campus does not need to know the name of the person who has experienced the harm or the harassment, but what Safe Campus currently does and will continue to do is ensure that the person who experienced harm be informed of options of where to find support resources and their reporting options, as well as have the opportunity to connect to a confidential advocate. Under this current Safe Campus Title IX protocol, if the person who experienced harassment or harm is willing to have their name provided, Safe Campus will directly provide them with information. If that person who experienced the harassment or harm wants to remain anonymous, Safe Campus asks the caller to pass on information to the person on whose behalf they're calling. A group at UW has already been working on determining the expectations of employees, and it will continue to do this work. In the meantime, we are working on identifying those individuals with the authority to institute corrective measures, and they will receive communications and be trained on what they must do. So with respect to the 2 tracks for complainants on this next slide, earlier I mentioned that a report or a disclosure is different from a formal complaint. So a complaint is a request for an investigation. The university is required to investigate formal complaints as defined and recognized by the federal regulations. An investigation and hearing will follow the federal process when the alleged prohibited conduct is that which falls into that narrower definition of sexual harassment I outlined earlier. In addition, the federal regulations require that the alleged prohibited conduct occurred in the United States and within an educational program or activity, or in a building that is owned and operated by a registered student organization, such as a fraternity or sorority. If both of these are true, the investigation and grievance process will follow what I cover in the next slide. If, however, the alleged behavior does not follow within this purview, but is prohibited by UW policies, or if the behavior took place abroad or in an off-campus apartment or outside of a university program or activity, the university's current investigation processes and procedures will apply. So moving on to the next slide, I'll cover investigations and hearings. Investigations and hearings conducted under the federal regulations will differ to some extent from the University of Washington's current processes, but many of the federal regulation requirements are similar to those that the university already uses, particularly for complaints that allege a student has violated the Student Conduct Code. UW already provides notice to all respondents, and we already apply the same standard of evidence to all investigations and adjudication processes for all members of our community, whether student or employee. The University of Washington uses the preponderance of evidence standard, which is to say that a person is only found responsible for a violation of a policy if the evidence supports that it is more likely than not that they engaged in the behavior under question. Under the federal regulations, hearings will occur in every case that involves one of those allegations of sexual harassment in that narrower definition. For students, evidence will be shared slightly earlier in the process than it currently is in cases that result in a hearing. Cross-examination that was conducted through a neutral third party or hearing officer will now have to occur by a party's advisor of choice or the university's appointed advisor for these cases under the federal regulations. We've already allowed advisors in our process. The main change is going to be that advisors have to conduct cross-examination, and cross-examination will now have to occur orally rather than through written questions that are then spoken orally by a hearing officer. Employees were only provided the opportunity for a hearing if it was required by a collective bargaining agreement or if one was required pursuant to the faculty code. Hearings in cases that involve allegations of sexual harassment, as defined by the federal regulations, will be a change for employees. However, given the narrowly defined conduct and jurisdictional requirements, the University of Washington does not currently anticipate a large number of hearings for employees. When hearings must occur in cases involving employee respondents, again, advisors will have to conduct the cross-examination. How evidence is considered throughout the investigation and grievance process under these new regulations will also be different, and we are still working to understand exactly what that will mean. Again, please direct any questions that you have to Glenna in the chat feature. Finally, supportive measures are a positive outcome of the regulations. The federal regulations codify what the University of Washington already does, and that's a good practice. Supportive measures are services or referrals that do not unduly impact the other party. The federal regulations require that they are non-disciplinary and non-punitive, and that they may include things like extensions of time for coursework, rearranging a course or work schedule so a party does not have to see the other party repeatedly, changing an individual's living arrangements, such as moving their residence hall or their room within a specific residence hall, changing an individual's work or desk location, and providing referrals to counseling or other resources, and creating a safety plan. Resources and supportive measures will be offered to both complainants and respondents, as well as students and employees. One of the bigger changes for the university will be how it issues no contact directives while an investigation and grievance process is underway. The university will also need to do more to document its current practices. At this point, I'm going to turn the presentation back to Valerie so she may talk with us about how the university is implementing these new rules.
Great. Thank you so much, Megs. So I'll talk for a few minutes about how we plan to proceed in coming weeks and months, and then I'll turn it back to Glenna to get to some of your questions. Given the short runway that we have between now and August 14th, we have identified a two-phase response to these federal rules. Phase one, which is now and up until August 14th, we will focus on coming into compliance with the mandate of the new rules. Specifically, this will include drafting emergency or temporary rules for the Student Conduct Code, which is codified or housed in the Washington Administrative Code, or the WAC. You'll hear us make reference to the WAC if you're not familiar with that phrase. We'll also be drafting interim directives or statements to bring other UW policies, for example, Executive Order 31 and others, into baseline compliance with the mandates in this new federal law. The other thing that we'll be working on has to do with awareness. The new federal law emphasizes that everyone needs to know who the Title IX coordinator is and how to report misconduct or seek support, as well as how to file a formal complaint. We will be reviewing our protocols, our language, and our messaging on multiple fronts between now and early August. And then finally, we'll be spending time in these next coming weeks, the weeks right in front of us, really identifying what adjustments we need to make in our practices and our protocol so that we can, for example, some of those things include designing a hearing process for staff employees that Mag just made reference to. We'll be modifying the student and faculty hearing processes as needed. We'll be adjusting our record keeping on several fronts as the new rules require. And we'll be training the staff who are involved in adjudications on the new requirements. Those are some of the things that we'll be doing. Once we get to phase two, which will be probably September 2020, and we're anticipating through April or sometime in the spring of 2021, we'll move into kind of a different focus with our work. By then, we will have already implemented the interim or emergency measures to ensure that we're in compliance. And that's the floor that I mentioned earlier. After August 14th, we can begin to pay more careful attention to the litigation that's going on, any other legal or political changes that might impact these rules and implementation, and then begin the process of gathering together our stakeholders, students, staff, faculty throughout the UW and the broader community to have a more in-depth discussion and problem-solving approach to this. Certainly, we're working with a wide variety of partners now, and we welcome input now, but with this short runway, we don't have the time to kind of do the work that we would want to do it, to be as inclusive and thoughtful as we can be, which is why we have the two-phase approach. With the more time that will give us, and when we're back from the summer break that many students and faculty take, we'll move into a process that allows our solutions to be more reflective of best practices, to be evidence-based, and to be community informed. We'll build up from and around that floor that I mentioned, and we're currently anticipating that, like I said, that we'll get to a final place with new rules and new policies in the spring of 2021. All right. So let me just say that we know and understand that many in our community are upset by these new rules. And this distress is exacerbated by the stress and hardship of the past months with COVID-19 and the deeply ingrained systemic injustices that are being protested these past days across our nation and the world. Holding space for that, I do want to underscore a few key takeaways that I believe are important to remember in this kind of small realm, this realm of the Title IX rules. First, let me just remind folks that the new rules apply to a narrow band of behavior. And while we still need to respond in a very prescriptive way to requests for formal investigations that meet the criteria of the new rules, we can and must still address behavior that is discriminatory, harassing, or otherwise unwelcome. And to accomplish this, we will have the two-track system you've heard described today. Third, in all situations, regardless of which track a complaint is on, UW will utilize equitable practices, will provide due process, and offer and implement supportive measures. Finally, let me just say that we are seeking and welcome and need your engagement in this work. For those of you who are interested in learning about our phase 1 approach, particularly the emergency rules that apply to the Student Conduct Code, please email us. We will engage, and we welcome that. For phase 2, when we can engage more broadly and without this short sort of sense of urgency with this August 14th deadline, we were going to ask for broader participation. And if you have recommendations on how we structure that, contact me directly. I welcome your input in that front. And I can assure you that as we turn the corner towards the coming academic year, we will publicize opportunities broadly. You can come to our Title IX website for updates, and we'll also be pushing things out to folks as well to seek your input. So at that